Good morning, everybody. Happy Thursday. Today is November 10th. This is the Subcommittee on Worker Continuation of Care, MLAC Subcommittee. The first time on the agenda is reviewing minutes from the October 20th meeting. We're going to skip that because the minutes were not sent out to us to look at. So I think for the essence of time, I'm going to jump down to the stakeholder proposed solution for updated problem statement. So between the two meetings, stakeholders from SAFE and OLA and the MCO community met, and then the culmination of their conversations are in a letter. So members, it was distributed to you earlier this morning. Those of you in the audience, it is available on the subcommittee's webpage. I put a link in the chat. And I will try and upload it as well there. So Matt, sorry, I turn it over to you, both of you, for next steps, because I believe you wanted to have Sally speak before stakeholders. Okay.
Yes. Thank you very much, Teresa. Matt and I, decided that we would like Sally's expert opinion on the number 4 option that is addressed in the letter after the stakeholders met. And then I think we'll go from there. If Sally, if you're ready or willing to help us be our expert on that, that'd be great.
Of course, I'm willing to be here with you. I thank you for the invitation. I won't try to put myself forward as an expert, but I'll share what I do know. I'll say for the record, Sally Cohen, Administrator of the Workers' Compensation Division. Thanks for inviting me to join you here today, co-chairs. So the bug letter notification process that we know today is rooted in the claim closure process. So this is something that has evolved over the years, really as a response to the system's need to have a way to close claims that are left open when the worker has abandoned their medical treatment. And as we know, this occurs for a number of different reasons, including when the worker has recovered from their injury, is just simply not seeking any further treatment. But WCD first established a process many years ago. It was first established by Bulletin, and this was actually numbered Bulletin number 9, and we've heard stakeholders refer to this Bulletin 9 process or B9 process for closure. That bulletin was later withdrawn, and the department we adopted administrative rules at some point. This is many years ago, but the essence of the rule was to allow the insurer to assume that a worker who had abandoned their medical treatment was in fact medically stationary and that they could close the claim. So our authority to establish that process was challenged, and a case was litigated and went to the courts, and the court agreed with the challenge and said that the department, we went beyond the statute, that basically no, you cannot presume a medically stationary status in the absence of a physician's finding that a worker has been declared medically stationary. And so our rule was overturned. And in 1995, so this tells you how long ago all of this has been happening. In 1995, there was a large workers' comp bill that year in the legislature, a pretty sizable reform bill that addressed some of the reforms from the 1990 changes. And so this bill amended a number of different workers' compensation statutes. And in that bill, it was Senate Bill 369, this added a process for an administrative closure into the closure statute. And then that is 656268. And so an administrative closure it follows a process to allow claims to statutorily qualify for closure in the absence of a medically stationary finding from the physician, which is normally what you need for a closure. So following that statute change in 1995, we again adopted an administrative rule, and that provides for the procedural steps for this notification letter that has become what we all call the bug letter. So the procedural steps for that notification and for the time frames for the worker to either seek treatment or for the insurer to then close the claim. So both the statute and our administrative rule, Teresa noted this in the current tools chart that she distributed. This is noted on page 4 of that chart. So in our auditors do confirm that in reviewing claims, they do see claims processors using that bug letter notification process to simply prompt some action from a worker who has kind of disappeared off the radar. But this isn't something we audit for, so we don't have any data. And so we don't really know how successful this is in prompting the worker to seek further treatment, but we do know it's the letters being used in that manner. To your ultimate question, co-chairs, does this address your problem statement from a statutory basis? And I would say from the department standpoint, we do know there's what I'll call kind of a secondary use of the bug letters by claims processors who are, prompting some response from a worker who hasn't been treating. But from the basis of how the current statute and rule are addressed, the process is pointed really to claim closure. So I'm happy to answer any questions you have about that. We also provided some data for you previously about the number of administrative closures.
This is Matt. I do have one question. So it sounds like there's what they would call like an off-label use to do the prompting. So there's an assertion that it would require some statutory change or to maybe make that less of an off-label use and to make it more of a built-in component to the bug letter. So is that required to go through a statutory change?
Thank you, Matt. I'm not a lawyer, so I would not come out and say that I am the expert to know whether that in fact is true. The director only has authority to promulgate rules based on this, the statutes that are in existence at the time. We are not allowed to go beyond or add to the statute. So for me, that actually would be a question that I would have before we were to promulgate, a rule that went beyond that statute. I would have that legal question. We probably need to consult with our lawyers.
Thank you.
And Sally, this is Sarah. This is extremely beneficial and hopefully we appreciate your knowledge and expertise in this. I know you don't want to be our expert, but we've deemed you as that. So, and I guess if we wanted to address it, would it have to be in a different part of the statute? Because this is a claim closure statute, not a continuation of care section.
Sarah, again, that's a very good question. I don't want to play lawyer. I would think that would be up to the Legislative Council on where a particular law needed to be inserted into the existing statutes.
Okay, I guess I'm just, talking out loud and
Yeah.
pondering. I would think it would maybe need to be in a different part if this is a closure statute. So that's just.
Yeah, that would be another question we would have.
Thank you, Sally. I appreciate your help.
You bet.
Tammy, you have your hand raised?
I do. Okay. I was really shocked at how long ago the bulletin number 9 was discontinued. And I just really thoroughly read the, OAR 436 or ORS 436, the administrative claim closure, this wonderful handout that I think it was Brittany provided to us. And I don't know, I'm kind of thinking that the TPAs and the insurance companies need to maybe reword their bug letter to be stronger. And these rules certainly allow for that. And then that would just really solve this problem that they're checking a box that that the insurance companies do not have to even provide. And so I'm wondering if we can maybe drop item number 4 because it's not going to address the other issue. This is just going to address one certain set where the injured worker says, yes, I'm still treating. No, I'm not recovered, but then they never actually treat. Well, when you read the actual rule, you can reword the bug letter to be a lot stronger and without having to change anything and having to change the statute. I think this is just up to the TPAs and the insurance companies to reword their bug letter. That's my opinion.
Thank you, Tammy, for that. Matt, do you have any other questions for Sally or Tammy or?
Maybe clarification, I guess, just clarification on what Tammy was saying, rewording their, so the individual insurance companies would be rewording their bug letter to be more aggressive to.
Oh, I don't really like the word aggressive, but just stronger with the rules here, because, you know, the rules say that they must close the claim if they're not returning to for care, and that really the injured worker just has the choice to say, I'm scheduled and this is my appointment, or I'm no longer treating, just those two options. And so they can't just reply, I'm going to have treatment. The reply needs to be, I have appointment scheduled on this date, or I'm no longer treating. And so those open-ended issues where they're saying, I still have problems and I'm going to treat, but then they don't, and then 30 days later, they don't actually go in and they just keep replying with that. If that's not an option, the option is, this is my appointment date. Even if they couldn't get in and their appointment date was like 5 weeks later, if they replied and saying, I'm seeing Dr. So-and-so on, you know, January 10th, then that would be, you know, an acceptable reply. But to give them an option just to say, I'm still having trouble and I'm planning to treat, is not really required in this rule. And it's the insurance companies and the TPAs need to reword their bug letters to where that's not even an option. Their option is, here's my appointment date, or I'm no longer treating.
Gotcha. I feel like the example that was shared with us, the example bug letter actually had in there that you had to require a date that you were going to have your, so I guess that's where I was confused, is there is the option of the insurance company to, in their bug letter, just to say, I intend to treat, but I feel like the bug letter shared with us by SAFE required that the worker put in a date for which they had another appointment. So that would be what you're advocating for, is that insurance companies make sure that the only option is that the worker has a date that they're going to be seeing when they
well, yeah, I mean, every insurance company can word it differently. And I've seen some where, you know, the worker, where it says, I've fully recovered, or I have not fully recovered and I'm planning to seek treatment, or I already have an appointment scheduled on this day. I mean, it gives them a whole lot of options. And if an insurance company or a TPA wants to word their letter like that, they certainly can. But on the example that, you know, Brittany sent to us with the actual, you know, 436-030-0034, they gave an example of the bug letter, which only has the two options. I have an appointment scheduled on this date, or I fully recovered, and that's it. And so I think if TPAs and companies want to put a stop to the ones that say, oh yeah, I'm still having problems and I plan to treat. Oh yeah, I'm still having problems. And then the next month, I'm still having problems and I plan to treat, but they never actually treat. Well, it's up to those TPAs to maybe quote the rule and change their bug letters. And I'm still going to call it a B9, even though there's no longer a bulletin 9. I just don't like bug letter. Anyway, they can change their letters if they want to make them stronger, and that will resolve the whole problem. So, you know, I talked with a few people yesterday and just really tried to digest and read this letter. And in my opinion, this resolves the problem, and that this statute doesn't need to be changed. And but it still doesn't address the other issue that we have. It's like there were two different issues, and I think this is pretty strong. I'm happy with that.
Okay,
Right.
so can we, oh, sorry, Matt, go ahead.
I was just going to ask, I don't know what a TPA is.
Oh,
Third-party administrator.
Yeah.
Thank you.
So like
okay.
my employer self-insured, and so my TPA processes our claims. We don't process them in-house.
Gotcha. Okay.
So before we take questions, can we just do a little synopsis and clarification? So Tammy, I'm hearing you say that you feel that the bug letter could be stronger as a closure process from the TPA or the insurer side, and that it doesn't really you're in agreement that by statute of claim closure, it doesn't address our issue of continuation of care in a problem statement.
Right. And I mean, I gleaned that answer with, off of a meeting yesterday with like Elaine and David, and reading this just really thoroughly, reading the bug letter, the mission statement and the issues. And I think that, in my personal opinion, there's already room in the rules to strengthen the bug letters, and that will address that one specific problem.
In the administrative closure process, not, okay. Thank you.
You're welcome.
I guess my, what I'm hearing though is that that from what Sally is reporting is there are folks who use it as a tool to prompt engagement. And so, it's like there is that operationally occurring in some respects. We can't necessarily quantify it, but now I am curious because systems that are successful tend to build off of things that are already being done, right? So if this is in existence and we have some organizations using it in some capacity to prompt workers to engage or to remain engaged, that I am curious of what the process would be to not to strengthen the bug letter in respects to closure, but to see if there's a way to build that into the process of the letter into this, because it's happening, right? That's the part that I'm coming to, is if it is happening, we should consider that people are using it operationally that way, and there may be a way to formalize that. But I will let Dustin has his hand up.
Yeah, I just had a question kind of directed towards Tammy, based on your reading of the documentation, and I would love to get directed to where that is. I don't have it in front of me, but I'd love to be able to refer to is it the statutes that you're?
Right. I think Brittany had sent this out to all of us, and Dustin, if you want to send me a private message with your email, I'll just forward this email to you right now.
That'd be great.
While we're all chat.
But the question that I have going along with the bug or B9 letter, in terms of kind of beefing it up and enforcing it a little bit more with the TPAs and the insurance companies, based on your reading of what the statutes indicate, back when I was an adjuster, one of the things that we ran into, in addition to kind of how weak the letter was to begin with, in regard to somebody could just check yes that I intend to treat, and that was it. You had to wait another 30 days. Would you feel that there's language that you could enter in that even if they say, yes, I intend to treat, and maybe they give a date, but then they don't follow through, that would prompt not requiring to send another letter 30 days later to then find out if they are intending to treat? Because somebody could schedule appointments and not follow through. And if they're technically meeting the requirement of the letter, then they're still kind of falling within that, falling between the cracks of they're not actually proactively treating, but they're giving you just enough that you can't administratively close the claim.
Yeah, I think that that's addressed in this rule. And if you read this rule, I don't think that they can do that. I mean, they have to actually treat, and it doesn't have to be actually treating within the 30 days or the 14 days. So if they can't get an appointment, like I had said earlier, for like 5 weeks, but they attend that appointment in 5 weeks, then that definitely meets it. So read this rule. I think that that is addressed, and that they can't just say I'm going to treat and then they cancel the appointment and they don't actually attend. I think that this can be closed. The claim can be closed in reading this rule. Okay. So, I mean, I'm not an attorney, so, I don't know if Kevin's here or Elaine. I see.
Well, let's see. Here. Sally, do you have an opinion on that?
The rule is real specific, as Tammy is noting. It does say that the claim will be closed unless the worker establishes that treatment has resumed by attending an existing appointment or scheduling a new appointment. or that the workers responded with the reasons for not treating were outside their control. So the rule is quite specific.
Mhm.
Okay, thank you.
Thank you, everyone, for your input on that. Matt, what do you think? Where should we like to take item number 4 in the letter addressing all of our points for solutions last or dated November 5th from Elaine and 6th?
Well, in light of that, that hearing there are folks that use it to prompt, I mean, it does make me curious if there's a way to adjust, but and I guess those are the legal questions around statutory. Is it rulemaking or statutory? I'm curious what Jennifer Flood has to say now that her hand is up.
Good morning, everyone. The bug letter, the 0034 process is used by the industry to prompt workers to seek treatment when they have not been seeking treatment. We do receive those calls. No, I don't have data on that. And in the cases where the letters may not say you've got to schedule an appointment, our office strongly encourages the worker, and we actually tell them, you got to make an appointment. You've got to get an appointment. You've got to get the date. You've got to get that to your adjuster. So I think that it can be effective for, hey, my time loss might end. They might close my claim because I'm not doing anything. What's up? We do get those calls, and we do encourage the continuation of making an appointment and making sure that the insurance company knows the date of that appointment. My one concern, I'll just share that here, is that if there is no check-in with the worker regarding is it reasons beyond their control, that's a concern for just shutting down a claim or shutting off time loss. So that's my input on that. Again, I'm not an attorney either, like Sally. We just deal with these types of questions all the time.
It's helpful to get your perspective for sure.
Thank you.
Well, considering, and I appreciate that, Jennifer, thank you. I guess considering that none of the stakeholders really had suggestions for how to change the bug letter or how to change the process, I don't know where to go with it. Knowing that it is operationally functioning that way, I do struggle with the idea that it's off the table, but then also that there aren't suggestions coming from any stakeholders necessarily on specifics to the process. I mean, I feel like that should be something to explore when I hear that it functions in that way.
Matt, I agree. I hear you as well, that the secondary use is being done outside of the claim closure process to prompt continuation of care. But again, no one has a suggestion on how to address it differently. And so I don't know how we address it if no one wants to provide a suggestion.
Right. So yeah, I guess I don't know, maybe it does seem reasonable to move beyond that for now.
Okay. Okay, so we're now at items 1, 2, and 3 referenced in the letter by Safe and Elaine Schooler on November 5th, 2022. And it is our intent, and Teresa, maybe you can, if you have any updates, to attend the MAC meeting on the 18th of November to ask for their professional opinion on those 3 items. And at this time, we thank all stakeholder input, but we are not entertaining any other discussion from stakeholders at this time on these 3 topics. And that is our plan moving forward. Matt, do you want to comment on that?
Yeah, I think that is a reasonable way forward to address 1, 2, and 3 of those suggestions. And it seemed like in the letter that the stakeholders, when they met, all felt that would be a reasonable way forward. And
that they were also not in agreement and bringing a solution forth to us. So for us to continue forward on the subcommittee and recommend a solution to all of MLAC, it is our path forward.
Yes.
Okay, Teresa, do you have any further input, or will that happen after this meeting on if we can get on the MAC agenda and what that would look like?
Yep, I think it's fine. The way that, and I apologize, I don't have a link to the MAC agenda, but the way that the agenda is drafted currently, my understanding is that there doesn't need to be a revision for the agenda because the subcommittee's work is specified in the agenda. And I'm looking at Kara to confirm she's nodding her head. So yes. So I think there really isn't. It's just I think what WCD needed to do is just let the MAC members know about the subcommittee. You and the both of you attending next week. So it's
Is
just-
that more of an in-person meeting, or is there a remote option for that?
It is in person and audio.
Audio only? Okay, so then would we communicate with you about what information we would like distributed to MAC ahead of time?
Yes.
Matt, are you able to attend in person or will you be on audio?
Can somebody remind me what times that will be?
I believe it is at 10. Let me hold on 1 second because it is on my calendar. So I've got it right here. Yes, 10 o'clock.
And where?
It's in room 260 of the Labor and Industries building in Salem. So it's like it's where we like we're MLAC when we generally meet in there. It's a big conference room there along the
Okay.
Capitol.
I think I'll probably be able to make that in person.
Okay, and we can send directions and all of that information to you, and a parking pass as well. We can get that for you.
Margaret has her hand up, an MLAC member.
Yes, thanks, Matt. I am just wondering if MLAC needs, if the subcommittee has the authority to reach out to MAC without MLAC approval, or at least advice and, some discussion.
Well, we can certainly do that at our regular meeting. We are geared up to offer our opinion and how we want to move forward at MLAC when it starts at 11:05.
Okay,
Will that work?
right. Yeah, it will
Okay.
work. Thank
Do
you.
you have any concerns, Margaret?
I do, but I will bring them up at, in front of the entire MLAC if that's okay with you.
Yeah, absolutely.
Okay, great. Thanks very much.
Okay, Matt, do you have anything else for the good of the order? Did we lose him?
We did, yes. He's having computer issues. He put that in the chat. So
Okay. Let's wait for him to come back. There we go.
All right. Sorry about that.
No worries. Do you have anything else for the good of the order, Matt, for where our plan is, and we'll report back to MLAC?
Yeah, I don't have anything else.
Okay, and then Teresa will look for minutes after.
yes, yes.
Or,
And then for the full committee, going back to Margaret's question, I will have the co-chairs prepped on a motion and such after the discussion of the subcommittee's work during the full committee.
Thanks very much. Thanks, Teresa.
You're welcome.
Okay, we appreciate especially today Sally's quick work on providing some professional opinion and guidance on the bug letter and the statutory use of it, and everyone else's input, and we will take it from here. Thank you very much.
Thank you.
Mhm.